may not think of judges as politicians, but all over the country they run political campaigns, take campaign contributions, and then go on to sit on their contributors' cases. Judges say that's okay, that they can rule fairly and impartially on cases involving their contributors, and the New York Times set out to test that question. We looked at the Ohio Supreme Court, where justices routinely raised $2 million for a single race, more sometimes than a candidate for the governor of Ohio raises, and asked the question of how often they vote for contributors who appear before them. And the answer was overall about 70% of the time, and in the case of one justice, Terence O'Donnell, 91% of the time. Judges say, probably correctly, that elections are here to stay. Americans like electing their judges. And once you have elections, you probably also have money that comes along with elections, and it's probably the case that the justices, the judges, have to raise money. But it leaves open the question of why judges don't disqualify themselves from cases involving people who have given them something of value. The usual ethics rules involving judges are that even trivial conflicts of interest, even a share of stock in a company, even a relative who's on the brief in a case before you, requires automatic disqualification. The American Bar Association has for years proposed a rule requiring the same kind of disqualification where a campaign contributor appears before a judge, but no state has adopted that rule. What the Times study found in the end is that money is pouring into a branch of the government where people don't expect money and politics to play a role.